Hi, my name is Ann Zachary. I'm the CEO of KPS for Parents, a special education advocacy organization headquartered in Southern California. And we support families of children with special needs as they navigate the bureaucracy of the special education system throughout the state of California, as well as in other states, but mostly in California. What I want to speak with you about today is specific to the school closures related to the pandemic. And if you are a parent of a child with special needs who is in a school district or a charter school or some other local education agency where the campuses have been closed down and you're having to do distance learning, you've come to realize that that may not be the best model of instruction for your child. But it may not be that that's not the best model, it's just how it's being delivered. And you may be struggling with the absence of services that are called for in your child's IEP that are not being pushed into your home, that are critically necessary in order for distance learning to have any kind of a positive impact on your child whatsoever. And that could include one-on-one aid support, that's actually a really big one, speech and language services, occupational therapy, psychological counseling. It just depends on what your child needs, but there are some services that just simply have to be provided in person. Under the different regulations that apply, the people who would have to come into your home to provide those services may be considered either essential healthcare workers or they could be considered essential infrastructure workers. And so we're going to talk about that today, specifically with how California has interpreted the regulations and the fact that the federal regulations, none of them have been waived. We don't want to see these protections undermined and eliminated. Students with special needs are at the bottom of the list when it comes to advocating for civil rights. We have so many issues going on right now in our society involving race, which are totally legitimate issues, and they completely overlap with special education when we start talking about the school to prison pipeline. The bottom line answer is that nothing has really changed in terms of what is legally enforceable. The only thing that has changed is where services are being delivered. So without belaboring any further, let's get into this topic. So before I get into the whole discussion of implementing the IEP your child already has, let's first do a recap of what an IEP is, what it contains, what each section of it is meant to accomplish, and then we'll get into whether or not that's happening in your in-home school placement right now. So all IEPs follow a particular flow, and that flow is spelled out by the federal regulations. So you start out with your present levels of performance, and for a child who's already on an IEP, that document's already been created. So the assessments that informed that document have presumably already been conducted, or you wouldn't have an IEP. So assessment data, classroom data, parent input, teacher input, all of those things inform the present levels of performance, and from that data you should be able to draw baselines for your measurable annual goals. Present levels of performance and baselines basically describe what the child can do at the time that the IEP was written. But presuming for the moment that your goals are actually properly written, they're measurable and they're written for 1 year's time, and what they're meant to describe is what the IEP is trying to make happen. An IEP is an annual document, and it is meant to describe what you're supposed to make happen for a kid within a year. Accommodations aren't necessarily things that need to be taught so much as they are things that need to be provided so that the student can have equal access to learning. So for example, if all the other general education students are able to walk into a classroom up a couple of steps, but you have a student in a wheelchair, a ramp is an accommodation to give that student equal access to that setting. It doesn't make it any easier for them to do the curriculum. It doesn't make it, it's not cutting any corners, it's not cheating, it's not giving them an advantage, it's leveling the playing field so they're at the exact same place as everybody else. That's all an accommodation accomplishes. So for students who need, for example, note-taker services in class as an accommodation, for whatever reasons, their disabilities interfere with their ability to take notes, which isn't the same thing as the ability to understand the instruction. They may very well be able to understand what the teacher is saying, but to follow that verbal description and the presentation that the teacher is making and write all that down at the same time, that might be where the processing issue gets in the way. And so the note taker service allows the student to pay attention to the teacher and not struggle to try and write down everything the teacher is saying, knowing full well that a copy of notes will be forthcoming and they don't have to stress out over it. And so as long as the notes are good and they match what the teacher was saying, that's the point of notes. The point of notes is to study later on. And does it help to take them yourself? If you're able to, sure. But if it's just going to make it more difficult for you to follow the instruction, then it's not a tool to help you. It's now something that prevents you from learning. And so that accommodation of note-taker services eliminates that conflict and allows the student to learn while still getting notes to study with later on, which is what notes are really for. But SAI, or Specialized Academic Instruction, is the actual core curriculum being taught to your child with using whatever modifications and accommodations are necessary to see that done. And to be clear, accommodations, like I said, just give a student equal access. Modifications actually change the expectation. This is what you do for a student who is not capable of performing at grade level, that's an unfair expectation. Doesn't mean they can't perform close to grade level, doesn't mean they can't approximate something that leads them in that direction. It just means that they're not at the place where they can do it at grade level, and so the curriculum needs to be modified for them to meet them where they're at and still move them forward. And then related services are services that are necessary in order for the student to still benefit from the instruction, but are not instructional services per se. So for example, speech and language pathology, transportation services, mental health counseling. There's 1,000,001 different kinds of related services, but these are things that the child needs in order to be available for learning, so that when the accommodations are provided and work towards the goals and the core content are done, they're not being burdened or compromised by these other areas that if they were addressed, would otherwise make education more accessible to them, and they would be able to progress according to the grade level standards more successfully with that extra help. Certainly communication is a huge part of learning, and if you are a child with speech and language issues and you're trying to learn how to read and you need to produce written work, then your communication issues are at the heart of why you're having trouble in school. You can't address the academics without first addressing the area of need where the problem actually lies, which is communication when you're talking about a child with a speech and language impairment. And then the very last piece of the puzzle is placement. And this is what's changed for everybody. And this is what I need to drill home for you guys. Placement is the only thing that has changed. None of the laws have been waived. None of the schools are exempt from the requirements of the IDEA. That has not happened. All that has happened is how the states are going to adapt to the situation now that the continuum of placement has been greatly reduced. What has not changed is the need to have present levels of performance to say where the kid was at the time the IEP was written, measurable annual goals that target where the kid should be after a year's worth of work, services that will see those goals met, and then an offer of placement that is the least segregated setting where those services can be delivered such that the goals are met. Now, this is the piece that's being compromised by the pandemic. Normally, what's the least restrictive environment would be whatever classroom setting is as full of typically developing peers and general education students as possible, while still being able to deliver the services that the student needs in order to meet the IEP goals. So if a child in an IEP needs the kind of help that cannot be delivered in a gen ed classroom and they need to be in a special ed class just for that, then that's the least restrictive environment in which those services can be delivered such the goals are met. And it's our kids who are in these more restrictive situations, or who could only access the less restrictive settings if they had one-on-one aid support, who are the most compromised by the shutdown right now, because they needed extra tools just to be able to avail themselves of the general education classroom or the general education campus. And now not only is the campus gone and the classroom gone, but so are those tools, but somehow they're expected to magically independently participate in distance learning online. I mean, that just doesn't even make any sense. And then add to that, a whole lot of school districts just stopped working on goals at the end of back in March when the shutdowns first started to happen, because they didn't know what to do. They just were dumbstruck. They had no contingency for any of this. And so, of course, once again, the kids with the disabilities are the last ones to get what they need. And so they languished from March until the end of the year. And I can pretty much guarantee, You know, knock on wood, but pretty much every kid in America on an IEP has due process claims right now because of all of this. Because no school district knew what to do. No state gave appropriate guidance, and we certainly didn't get appropriate guidance from the federal government because, of course, they're hands off with this whole pandemic and it's not the federal government's problem. So they're deferring to the states. They're pushing everything to local control, you know, local government. And so now we've got all these local government officials who do not have the tools that they need, the guidance they need, and all of the cracks in the system are now exposed. There's no pretending that these people actually know what they're doing. Way too many of these people are just going through the motions. They always have done that. And this is why those of us who do this line of work have had jobs for the last 30, 40 years, because it wasn't like they were complying with the law in the first place. And so now you add this whole situation on top of it, and there's just no getting away from it. People can't, there's no more cracks for these people to hide in. There's no way for them to break the rules and get away with it. And for those people who didn't even realize they were breaking the rules, they had no idea that what the rules actually were. There's no place in public education for people who don't actually understand the public education system's mandates, who don't actually understand the job they've been hired to perform to the benefit of the public good. You know, these are people who think of their constituents as a means to a financial end for themselves. Students exist to give them a paycheck. They don't get paid to help students learn. And so, you know, that whole backwards mentality that has been pervasive throughout special education, all of these decades, ever since what was the precursor to the IDEA, the Education for All Handicapped Children's Act, passed in 1975, these people have been fighting that from within this entire time. And now that this pandemic has happened, they're trying to engage in the same lying and cheating behaviors that have gotten them this far, but it's not working anymore. Because all of these issues with how their agencies were being operated are now exposed. And now reform is imminent. There's no way to avoid it. But in the meantime, the laws are as they have been. They remain enforceable. And your child still has protected rights to present levels, measurable annual goals, services that will see the goals met in a year's time, in whatever placement represents a continuum of placement and is the least restrictive setting in the moment. And that in the moment, for a lot of kids, it's their living room. Just because the placement has changed does not mean that the whole rest of the IEP just suddenly gets tossed out. That all of the services that the child needed before to meet the goals, none of that's changed. They still need those services to meet those goals. And so this is where a lot of parents are flummoxed. They're just like, what do I do about this? So this is where the rubber is meeting the road, and this is where we want to help you guys. So assessments. So there's several situations that call for assessments. Obviously in the very beginning, when you first try to get your kid into special education, in the very beginning, when a child is first referred to for special education, an evaluation is done, an assessment is conducted, or a body of assessments are conducted as part of an initial evaluation. That initial evaluation is comprised of this body of assessments that is meant to figure out what the heck is going on, whether the child is eligible, and what to do once the child is put on an IEP. The what the heck is going on are your present levels of performance. And then whether or not the child is eligible just depends on the assessment data. And then, presuming the child is eligible, that data is then used to inform the present levels and baselines and create the IEP. The goals are written to describe what the kid needs to learn in the next year. The services are selected that are necessary to see those goals met. And the placement is normally chosen after that point. In this situation now, during the pandemic with kids at home, the placement options, and of course, when school comes back, once the schools reopen, God only knows what the placement options are going to look like at that point. And so we can't even make predictions about that. We can't even give guidance as to that at this point because we just simply don't know. What we do know is what's happening right now. And what's happening right now is that kids are at home and the laws have not changed. Now in California, there has been a little bit of a change in the law, but in favor of students. In June, the California State Legislature passed new regulations that require that whenever there is an emergency situation that causes a break from school of 10 days or more, that when that happens, whether it's this pandemic or any future catastrophe, then IEP teams have to convene to talk about what the kid is going to get during distance learning that will continue to work on their goals and provide all of the services necessary to see those goals met, even if they're being served someplace other than at school. And so we now have those regulations in place. They're enforceable right now. They have been since June. And more or less what's being required of the schools is that when the schools finally do reopen and they have the full complement of resources available to them that they had before, that if any students are at that point due any kind of compensatory education to make up for what they didn't get but should have during the shutdown, then IEP teams have to figure out how much compensatory education they are due and write that into the IEP. So California has thought ahead in terms of all of this about what are we going to do when this pandemic and these shutdowns are finally over and we're going to have kids who are still owed compensatory remedy. And then what do we do to prevent all of these kids throughout the state, because we've got hundreds of thousands of special education students in the state of California alone. What are we going to do with all of those kids when they all come back at once and they all need comp ed? We can't deliver comp ed en masse like that. How can we prevent the need for that much compensatory education, which is what everybody should have been thinking all along, but you know, common sense. So with respect to assessment, whether assessment is being done in the very beginning to find a kid eligible for special ed, or it's being done as a reevaluation, a triennial evaluation, because once a kid is on an IEP, that student has to be reevaluated every 3 years in order to determine if, one, are they still eligible for special ed, and two, presuming they are, what are we going to do for them now? Another reason why you might need to do evaluations right now, which is unique to the pandemic and the shutdown, is because we've had so many kids regress in the absence of appropriate intervention, and now all of their present levels are inaccurate. That what was their present levels of performance at the time their annual IEP was written, that was true, perhaps, hopefully, but it certainly isn't the truth now because they've been going without for months. And these were kids who were vulnerable to regression in the first place most often, and these were our most severely impacted students. And they were the ones who needed these intensive in-person supports the most, and they did not get them. And so now they've fallen so far behind that when instruction resumes, they're going to have to go back and relearn things they had learned before we can start teaching them anything new. And that's a problem. And that's the whole issue with regression. When you have a kid lose ground and then you've got to make up the lost ground before you could even start working on what they should have been working on while you were working on lost ground, they're constantly behind. I mean, for some kids, catching up from something like that is just impossible, and they're always going to be screwed. And it's not fair. It's completely not fair. This is why this is such a big issue for these families. And if you're one of these families, you feel what I'm saying here, that your kid is losing ground, and now it's going to take them even longer. And these are the kids who are going to be due compensatory remedy even after we fix what's happening right now as a prospective matter of faith. We can fix, the present and the immediate future at the IEP level. And hopefully your education agency will work with you to come up with a plan for compensatory remedy for the regression your child has experienced during this time. If your child did regress, they owe your child back education, because that was not your child's fault. It certainly wasn't yours. And your child has a federally protected right to a free and appropriate public education, which includes all these things, the goals and the progress and the present levels and those services and all of that stuff. That's federally protected rights. They can't just say, oh, well, we don't know what to do, so we're just not going to do anything, which is what happened. So now they have to make up for that. So the only way you know what your child now needs, because everything's changed if your child has regressed and lost ground, is you're going to have to conduct new assessments. You're going to have to get a handle on how much ground have they lost. What did they know at the beginning of this annual IEP period, and how much ground have they lost since then? How much did they learn before the pandemic hit? I mean, thank goodness it was like the last quarter of the school year, but still, how much did they lose during that last quarter, and how much time is it going to take them to recoup what they've lost? And at what point can we actually start working on what they would have otherwise been working on the first day of school if they hadn't regressed during the last part of the last school year? There's all this makeup that's going to happen. And so you don't know what to necessarily do for a kid until you do these assessments to figure out where they are right now. And so that's why assessments during the pandemic, during shutdown, even if you're still in a district where things are shut down, and you're doing distance learning, not by choice, they still have to test your kid. And I'm aware that at least one school district in my local area has figured out a way to do in-person testing safely using PPE and safety procedures so that the kids can go to the empty school campus, the otherwise empty school campus, and participate in that testing. And so it's not that it can't be done. And one of the things I'm going to be doing as soon as I get a copy of those written protocols for what this particular school district is doing, we'll be sharing that information once it becomes available. But the thing to understand is that regardless of the type of assessment you're doing, whether it's an initial evaluation, it's a reevaluation for a triennial, or your child's present levels have just changed so markedly that the present levels data in the IEP is no longer applicable. Now you're going to have to do new testing. Regardless of why testing is needed, you still have to follow the rules for testing. It has to be in all areas of suspected disability and student need. It has to be thorough and comprehensive enough to actually inform the development of a proper IEP. And by proper IEP, I mean that it is reasonably calculated as designed to render meaningful educational benefits to an appropriately ambitious degree relative to the student's unique individual needs. That is the legal definition of a FAPE when it comes to IEP design. If the IEP is poorly designed, a FAPE is automatically denied. If the IEP is not designed in a manner to fit the child's needs, a FAPE is automatically denied. If the child is failing to receive educational benefits, regardless of what the IEP says, a FAPE is being denied. If the child is being denied educational benefits because the IEP is not reasonably calculated to render appropriately ambitious educational benefits, then you've got a double whammy of a FAPE violation. A free and appropriate public education, a FAPE, is your child's protected right, and that's legally defined in a number of different ways. And this is, the fact that the IEP is supposed to be reasonably calculated to render appropriately ambitious, meaningful educational benefits to your child, according to the peer-reviewed research and evidence-based practices. That's the law. And if your child's not getting that, your child's rights are being violated, plain and simple, pandemic or not. That's the case whether the schools are closed or not. So once you get your assessment data, or maybe it's informal data that just comes from your child's distance learning teachers, like, you know what, we're running into some brick walls, and here's where the rubber's meeting the road. Here's where we're running into problems. And you're going to have to tweak the IEP. Or, let's say, for example, your child's IEP calls for a service that was being delivered during school on campus when the campuses were still open, but it has not been delivered in your home. And it needs to be, because your child can't learn without it. If that is the case, then it's going to be necessary to revise the IEP to reflect what they're going to do for your kid during distance learning. And there have been a whole lot of school districts that have been balking against that and trying to say, we aren't going to do anything, and we can't do anything, our hands are tied. No, they're not. Adherence to the IDEA is democracy at its best, because it's democracy that gives us the IDEA. The IDEA is a manifestation of a democratic state. The people who are fighting it, the people who oppose it, do not believe in democracy. And so do not feel bad like you're hurting anybody's feelings when you go in and raise hell to get services for your kid. And by raise hell, I mean in every legal sense of the word. Don't go down to the school district and act like a jerk. Organize a protest in front of your school? Yeah, that's probably not a bad idea. Wear a mask. But in terms of, how to go about this, giving them hell and fighting the good fight just means being smart and being more informed than the people you're up against, because I promise you, they have no idea what they're doing. Again, IEP revisions are not going to deviate from what your kid's IEP should already have in terms of the types of content. There should be new present levels of performance if your child's present levels have changed, and if your child has regressed, they have. So that needs to be updated with whatever data you've got. Measurable annual goals. If the goals are not due yet, but they're behind in being met, you may need to not amend the goals and reduce the expectation, because that's reducing the expectation not based on your child, but based on the circumstances, and that's not fair. Your child was on target to learn that within a year's time, were it not for the shutdown, and they're still owed that outcome. They still would have been able to achieve that goal in theory had the shutdown not happened, or the team wouldn't have agreed that it was an appropriate goal to put into the IEP in the first place. So to start watering down goals at this point, No, no, do not agree to that as a parent. Do not, do not, do not. Your child's needs may have changed, but not what they need to learn. You may have to come up with some sort of strategy about how you're going to bring your kid back up to speed, but reducing the expectations for your child, that also reduces the obligation of your education agency, which is what they're really going for. The same things that were, the same sections of the IEP are going to obviously be in the next one when you have to revise it. If the goals were due, if your annual IEP is actually coming up in the middle of all of this and it's time to write new goals, bear in mind where your kid should have been right now had the IEP not been disrupted. Look at what the goals targeted in the first place and look to see the degree to which your child met those goals. And I'm saying, as an educator, not as a legal professional, because I'm not an attorney, I do work as a paralegal and I'm a lay advocate, but I'm not an attorney. If your child was on target, let's just pick something easy and that's super easy and measurable to use as an example. If your child had a reading fluency goal, say your kid's in 2nd grade, let's say that this kid has a goal targeting 2nd grade level at 80 words per minute. And at baseline, he was at beginning 1st grade at 70 words per minute. So this is an aggressive goal. We're trying to jump up by a whole grade level, and we're also trying to increase the words per minute. And so now let's say that shutdown happens in March. You've been shut down since March. And now school's starting, or it's about to start, and it's going to be distance learning again. And your kid has not met that goal because nobody's been working on it with them. You've been doing what you can, but you're not a specialized expert special education teacher. In theory, the people who go into special education have unique expertise that the average layperson does not possess. No one can expect a parent who is not also an expert in special education to do what an expert in special education would do. Either you're trying and it's not working because you don't know what to do, or you're not doing it because you know you don't know what to do, and you're not going to injure your relationship with your child over some government agency's failure and create that kind of heartache in your home when you're all trapped in there together during shutdown, which is entirely understandable. You can't own that. That's not yours. And so if the instruction and the services your child needs in order to meet that goal have not been delivered, and now the goal is not going to be met, the answer is not to reduce the expectations for your child. The answer is to increase your expectations of your local education agency, because they were perfectly content to work towards that goal until things changed. And when things changed and they started bouncing off of each other like a bunch of incompetent ninnies instead of coming up with a plan and helping you, they've left you high and dry now for months. And now your kid is behind. And now that goal isn't met. And now what? Well, this is where you're going to have to come in and assess, because there's no way to answer that question without getting new baselines. What are his baselines now? And if your child had met that goal, what would have been the next step up? Which is difficult. It's speculative up to a point because your child didn't meet the goal. And it could be that your child wouldn't have met that goal. They may have fallen just short of it. Or maybe it was too aggressive and they couldn't realistically meet it in the first place. But if the child was on track to meet the goal, save but for the shutdown, and now all of a sudden the goal is not met, then it stands to reason whatever that instruction was that they didn't get still needs to be provided to get them to the point where they can meet that goal. So I'm advising you from an educational standpoint, if you're talking about preventing the need for compensatory remedy later on, target the newest goal for what should have been the outcome you would have targeted if the shutdown had never happened. If hypothetically your kid had met that goal on target in the classroom during the normal school year, like he was supposed to, like everybody thought he would, what would the teacher have proposed as the next year's goal? Insist on that and say that's where he would have been if you had provided services during the shutdown. So that's where I expect him to be a year from now, in addition to, not only with what you're going to do for him in terms of his right to a FAPE, but also the compensatory education you're going to have to deliver to make up for the fact that you didn't give him those services during shutdown. And so do not let them reduce the expectations. unless that's what your child truly needs. If it's based on your child's unique needs, that's one thing. But if it's based on the fact that they screwed up, no, there's no reason to shortchange your child and now keep your child perpetually behind. That's not okay. Related services, whatever services are necessary in order to see the goals met, bearing in mind that placement is now in your home. And there is no continuum. There's not all these different options of where your kid can go. There's only one place your kid can go, which is nowhere. So, for so long as placement, the continuum of placement is limited to your home, all that tells you is that they're going to have to figure out how to deliver the services, not whether to deliver the services. And this is where a lot of the disputes in special ed that are happening right now lie. You have school districts determining that they just aren't going to provide the service, which is illegal. They can't do that. And they're going, well, we can't do that right now because shutdown, pandemic, blah, blah, blah. No. They still have to meet those goals. How are they going to meet those goals if they don't provide the service? And this can include services in home. And one of the things that I've been seeing right now that just blows my mind, it has got to be about 8 million different kinds of stupid, is one-on-one aids being provided to a student online. So not sending the aide to the house to sit next to the student so that they are able to attend to the online instruction, which is what that person is for. But they're putting the aide online as well. So you've got a kid who has no competence at being independent, who's supposed to somehow magically independently log into Zoom and participate in the instruction, while their aide is also on Zoom, zooming in from home, like somehow that's going to work. How do you get the kid to pay attention to the aide when you need the aide sitting right next to the kid to get the kid to pay attention to anything? And so it's just, again, 8 million different kinds of stupid. I don't know who thought this was a good idea, but I can tell you what they were thinking. Well, procedurally, we have to provide an aide. So if we provide the aide online, we've procedurally complied. And this is the problem with special ed by and large. It always has been. You have way too many people who think it's about how can I get away with doing something. And as long as I fill out the right form or I call it the right name, then I've satisfied the procedure. And that's all I have to do. No, that is not all you have to do. The procedure is not arbitrary. It exists for a substantive purpose. It's supposed to make things happen. A school district person just arbitrarily filling out a form, regardless of whether what they put into that form actually does anything productive or not, is not compliance. Just because they used the right form does not mean they got the job done. In special education, students can have procedural claims and they can have substantive claims. Procedure is that the school district didn't follow the rules. They didn't check the right box. They didn't use the right form. They left something out of the IEP. They didn't follow the proper procedures to notifying parents of something. Those are procedural issues. But you can go back to the 1982 Rowley decision, which in part has been overturned by Indrew with respect to the definition of a FAPE and the basic floor of opportunity and meaningful educational benefits. That's a much higher standard now. But there are other parts of Rowley that are still quite applicable and enforceable. And one of the most significant passages in the Rowley decision is the acknowledgement that Congress contemplated that procedural compliance with the IDEA would result in substantive compliance. And it's the substantive piece of it that's the most important. So when people start putting more importance on the form rather than the function, you've got a problem. And that's what we've been dealing with in special education all along. I've got parents receiving documents titled prior written notice that are full of all kinds of unlawful crap about what the schools are not going to do for their kids right now. And all the schools have done is make the record and given us evidence that we can use to hold them accountable. The fact that it's on a PWN form doesn't make it legally compliant. They complied with procedure by providing a written answer, but their answer was substantively wrong. So they've chopped off their nose to spite their own face. They haven't solved a problem at all. They've actually just invited a bigger problem upon themselves. You know, a judge has the leeway to determine that a procedural error is harmless because it didn't result in any kind of substantive harm. An example would be in California, if a parent requests copies of their student's records, of their child's records from the local education agency. In California, the school has to provide, the education agency has to provide those records within 5 business days. End of story. That's the mandated timeline for the provision of student record copies to parents, period. If it takes 6 days, if the parents don't get the records until the 6th day after their written request was submitted, is that a procedural violation? Yep, absolutely. Does it result in substantive harm? Probably not. It really comes down to the substance of what's being done. And so they're going to go through all these procedures, they're going to use all these forms, and they're going to send you all these official things, and it's going to look, ooh, you know, it's coming from the district or their lawyer or whatever. You have to look at what the words on the page actually say. Don't get intimidated if it looks like an official form. Don't get intimidated if their lawyer sends you something that's, you know, looks all lawyerly. Because they do that on purpose to scare people. It's called an intimidation tactic. They're trying to get you to back off because you're squawking too loud and they're freaking out. So keep up the pressure, but maintain your dignity. Don't stoop to their level. Don't do anything petty or childish or emotional. Always come back at them with facts. Always come back at them with rules. Say, look, here are the facts. Here are the rules as I understand them as a lay parent. I'm not an expert. I'm not an attorney. You know, this is my understanding of what the rules are. How am I wrong? And then you put it on them. And that has to come back to you in a prior written notice. I'm requesting this. You tell me why what I'm asking for is wrong. Because the law requires them to. The thing you need to understand with revising the IEP is that they shouldn't be changing the IEP to make it easier on the education agency. They should be changing the IEP to make it so that they can deliver services to your child under the circumstances. That's the only reason to change the IEP. If things have changed with respect to your child's needs and now your child has regressed, this is not cause for them to reduce the expectations for the next annual IEP. That denies of FAPE. What they owe is compensatory education to bring your kid back up to speed. And so that's what you need to be advocating for. Don't let them water down the next annual IEP. Don't let them revise the IEP to reduce what their burdens are. Because that's not about what your child needs. It's about them not wanting to have to do the work to provide your child what your child needs. They're trying to make it easier on themselves and at your child's expense. And then once you have an IEP that's worth implementing, depending on whether you're in a consent state or not. In California, we're a consent state, so no IEP can be modified, changed, or anything without the parent's written consent. Parental consent is required for anything having to do with new assessments, an initial IEP, those kinds of things under the federal regulations. But in consent states, state law will add another layer of protection that says that any IEP that gets created requires parent signature before it can be implemented. And in California, we have additional protections that allow the parents to give partial consent. So they can consent to the parts of the IEP they agree to. So those parts can be implemented right away, and the parts that are in dispute can be resolved separately. And so parents have the right in consent states to do that kind of a thing. Don't sign consent to something that doesn't make sense for your kid. It's going to be so much harder to undo that damage once it's been done. If you are not in a consent state, if you're in a state where the school people will just say, here's the IEP, screw you if you don't like it, and then your only other option is to file for due process to get it changed, then those are your mechanisms. And that's what you're going to have to do. Now, that isn't to say that you can't call another IEP meeting and try to renegotiate the language of the IEP, but my advice to parents is only give school districts, give them a second chance when it makes sense to. Give them a chance to do it right. Even give them a second chance to do it right. But don't keep handing out extra chances every time they blow it. The first time really should be it. They should get it right out of the gate. But human beings are human beings. They make mistakes. It's totally fair to give them another chance to do it right. And I very often do. I say, look, I'm not trying to be a jerk here, but this is not accurate and we need to fix this. And very often schools will work with me and they appreciate what I have to say. Because basically as long as they fix it, they're not going to get sued because now it's right. There's no reason to sue them. So I'm actually helping the schools whether they realize it or not. So If you have to go and fix something that way, that makes sense. But don't change things just to make it easier on the schools. And understand that no educationally necessary service can be lawfully denied. If your child needs it, your child needs it. And if it's educationally necessary, it's educationally necessary. And in California, any in-person service that is educationally necessary, even during shutdown, means that the people who have to go into your home and provide those services using appropriate safety protocols, those people are essential infrastructure workers. And the State Department of Education says so much on their website, and I'll include links with this video for all of this. The other thing I'm going to include with this video, for those of you, just as a reference, even if you're not in California, we recently, just this last week, had a due process case that's been pending since before all of this. And this poor little girl had to go and get a stay-put order in terms of what her services were during the pending lawsuit before the shutdown. Because even as the lawsuit was pending and they hadn't gone to trial yet, the school was trying to take away the services that were already consented to in her IEP. And so the family had to go and get a stay-put order from the judge saying, no, you have to leave those services in place. That's the law. Stay put is a part of the IDEA that says that whenever a dispute arises over the child's services and placement, that the last agreed to implemented IEP is the IEP in force, that whatever that IEP contains is stay put unless the parties agree to some other interim arrangement pending the resolution of the dispute. So this child already had to go get a stay put order, her parents did. Had to go get a stay put order just to enforce what she already had while the dispute was pending. And then the pandemic hit and the shutdown occurred, and suddenly her school district like, oh, how unfortunate, we can't deliver services because of the shutdown, lie. This family had to turn around and file another motion for stay put to keep those services in place pending this due process suit that still hasn't been tried yet. And what you'll see when you read this thing is so gut-wrenching. This is a medically fragile child who needs a whole lot of intensive one-on-one nursing support in order to participate in instruction. And they're taking away a one-on-one nurse to a medically fragile child and saying, oh, we can't, shut down, pandemic. Under what circumstance is it appropriate to take away a child's one-on-one nurse that they need in order to access education when they're wheelchair bound and unable to move their own bodies or speak or feed themselves or toilet themselves, and you're expecting this kid to go on to Zoom and log in and participate independently? The fact that that just defies every kind of logic imaginable goes to the extremes that some of these people are going to just get out of their responsibilities and use whatever excuse they can, and at the expense of our most vulnerable students. Our students who need the most help are the ones who are least likely to get it in the first place, and this has just made everything worse. So nothing exempts your public education agency from abiding by the IDEA. They can't deny services that are already in the IEP that are necessary in order for your child to receive educational benefits. And presumably they wouldn't be in the IEP if they weren't necessary for your child to receive educational benefits. So you're going to be due back education. Your child's going to be due compensatory education for whatever they didn't get during shutdown that they should have. Proving what they should have gotten and what was educationally necessary shouldn't be hard, because on its face, whatever was in the IEP was educationally necessary, or the team wouldn't have agreed to it. For me as a scientist, this is a huge deal because it gets lost in the mix. Everybody gets so wrapped up again in the procedures that they don't understand the substance. The substance is where the science of all of this is. And you have way too many people involved in special education who have a background in administration and no background in science, much less the science of how you teach people things. And so they don't understand what any of that means. It's all a bunch of gobbledygook to them. They just want to see, how much money does it cost? Because they don't understand their public servants. They think their job is to somehow not spend public money on the public. But the regulations require, specifically Title 34 Code of the Federal Regulations, Section 300.320A4, mandates the application of the peer-reviewed research to the design and delivery of special education to the degree that it's practicable. There is nothing here that is not practicable. It is difficult, it's inconvenient, it's cumbersome, but it is not beyond practicability. And that's something that you need to drive home, is that your child deserves to have a real program that's based on things that have been proven to work. That is evidence-based practices, which have only been proven to work because of the peer-reviewed research. That's why the research is conducted, to figure out what works. And once we prove what works, we are supposed to take that knowledge and deploy it into the field. Unfortunately, there's a huge barrier to that. And that again is another video, another day. Just take it as a given that there's a huge barrier, that the science has a difficult time making its way into the classroom. That even though we know what works for these kids, trying to actually get it deployed can be very challenging. And certainly under the current circumstances, that's the case. So that having been said, the schools are not exempt from applying their evidence-based practices in the peer-reviewed research. And so you have to keep insisting on that. You don't take out services from my kid's IEP just because you find it inconvenient. Don't strip the science out of my kid's IEP, the things that are proven to work, because you find it inconvenient. My kid does not need to be warehoused. My kid needs to be educated. This is the general argument you're going to be making. And that's this presentation. I know this has been a lot. I tried to keep this as short as possible. Trust me, I skimmed over these topics. Each one of them is worthy of not just a video, but a documentary series unto itself. And so I didn't want to get too hard and heavy with all of this, but there's a whole lot of technical underpinnings. But hopefully I've given you enough of the broad picture of what's going on that you're going to be able to advocate for your child more effectively. If you're a professional coming at this and you're watching this video, which is really meant for parents, I appreciate you coming and watching it, because you guys need to know what I'm telling the parents. You need to know. It's not like I'm coming after people. It's not like I want anybody to suffer. The whole point is that I don't want people to suffer. The whole point is that people are suffering. And I know that there are plenty of educators in the public education system who are so frustrated with their administrations, that there are wars being waged that the public doesn't even know about, going on between the school districts and the unions about what's safe and what isn't. That we have to protect the health and safety of our educators, or there's no one here to educate our children, and we need all of our highly qualified expert professionals healthy and on board. We're not asking for you to show up in the emergency room and risk breathing in COVID. We're asking you to one-on-one with PPE, provide in-home aid services, provide in-home occupational or physical therapy, or nursing services. A lot of speech and language can be done online, but not everybody responds to that model. So if you're an educator coming at this, understand this is not about me trying to endanger you or your family. Obviously, if anybody in your household is at risk, you should not be going and doing any in-person services. But if we're talking about a registered behavior technician who's a college student or recent graduate and is working towards their master's in a BCBA, and they live in an apartment by themselves, they're not in a situation where they are exposing themselves and they're maintaining social distancing in their personal lives otherwise, for them to go into a home where everybody's socially distancing, you're going from one secure setting to another. You know, if the aide gets in their car and drives from their house to yours, and they don't stop anywhere in between, then they're not going to get exposed to COVID in transit. And they're not going to bring it into your house. If they don't already have it in the first place, they've tested clean, and that's really something that needs to happen, is before anybody goes into anybody's home in person, they should be tested. If we're all careful about how we go about it and we don't take any unnecessary risks, we're going to be able to provide in-home services to those kids who just absolutely cannot function without it, and get them back to where they're supposed to be, so that by the time school starts back up and we are able to reopen campuses, whatever that looks like, they're going to be ready to come back and they're not going to be behind. And that just has to happen. There's a way to do this that minimizes risk. There's a way to do this that's as safe as it can be. I'm hoping that this information will be helpful to you and that you can use it to advocate effectively for your child. If you have any questions, again, our email address is below. Please like and subscribe, and we look forward to helping you again soon.